We also have the European Network of Independent Living, ENIL. And with us today, we have Ines Bulic. Would you like to say a couple words to introduce ENIL, please?
Hi, thank you, Ola, and hello to everyone. We are very pleased to be co-organizing this interesting webinar with disability rights defenders and Article 19 as a tool. ENIL is a user-led EU-wide cross-disability network. We bring together mainly grassroots organizations from across the Council of Europe area, organizations of disabled people who campaign on the right to independent living, access to personal assistance, deinstitutionalization, peer support, and other things that are necessary for disabled people to enjoy the right to independent living. We are always very happy to partner with disability rights defenders, also to help our members and activists expand their knowledge on legal issues and access information on how they can use the law to access the right to independent living. So this is it from my side. I'm also looking forward to hearing everyone speak today. Back to you, Ola.
Thank you. We will have a look at the agenda now. The times are not correct, as you will understand, due to the slight delay. I will just briefly introduce the topic. After me, we'll have Paul Lappalainen speak, a Swedish US lawyer, and also part of the European Equality Law Network on access to justice and access to remedies. After that, we have my colleague, Mari Silsalu, who is working with the Article 19 project in Independent Living Institute, who will give you an overview of a survey that we did earlier on the legal remedies for the rights of persons with disabilities, where we had a global outreach in the answers that we got. After that, we have Anne Campbell speaking from Validity Foundation. She's the co-executive director there, looking beyond compensation for innovative remedies for women with disabilities. After that, we have a break. We will see at what time exactly, perhaps a little bit after 3 now. After this, we have Stellan Gärde, a Swedish lawyer and author, who will focus on legal aid as a human right. So to connect remedies to actually being able to use them. And finally, we have Timothy Hodgson, legal advisor at the International Commission of Jurists and lecturer at the University of Pretoria, South Africa, who will give us insights into economic and social rights litigation, which I'm really looking forward to better understand how we can work with economic and social rights also in practice. Following, we will have a discussion until we finish the webinar. So I'm hoping for a deepened dialogue on this very important topic on remedies for the rights of persons with disabilities. So before we move on to Paul, I'll briefly say something on why we're doing this. The main reason is that we've found that if we're going to use the law as a tool for social change, we need to better understand where we can and how we can use them in the legal system. Usually when the disability movement, at least in Sweden, demand change, they demand laws and they want them to be implemented, but they don't normally use strategies to actually have the change behind the laws materialize through legal action. So we've begun to focus on strategic litigation and other things to actually have the laws be used in action. And we've also understood that the remedies we have in Sweden, they're quite limited. And if we expand our views and look at how other countries do it, I think we can learn a lot. And hopefully this meeting today can lead to a better discussion in Europe, globally, on how we can learn from each other for how to have better legal remedies and how to use them in a more efficient way. So with that said, I would like to give the floor to Paul Lappalainen.
Okay, thank you, Ola. Let's see if I'll move straight to my PowerPoints If I can get them up. Oh. Okay, I put the title Disability Rights Enforcement, Remedies and Solutions. I can say quickly about my background. I'm quite old to be doing a PhD, but one thing I'm working on right now is a PhD, a comparative analysis of the development of equality law from the US, Canada, through the UK, EU, and then to Sweden. And I'll be, given the time frame, I'm only going to be touching on a certain amount of issues, but this will be sort of a comparative framework. But naturally, I have some focus on Sweden, at least some of my examples do. Here's structure, preliminary issues, attitudes or behavior, power and enforcement, then enforcement by who? Usually we're looking at equality bodies, at least in continental Europe, there's been a reliance, and or civil society. What's the role of civil society in terms of both legislation and litigation? And there's the issue of remedies. What's the goal? We have, in Sweden, there's a primary reliance on damages or money damages. But there are possibilities concerning equitable remedies or court orders in certain countries. Settlements can also be relevant in certain situations, especially since damages, only in terms of money, do not necessarily get the results that you want. And then there's a question of power. How do civil society organizations in particular work with the courts? It's important with good advocacy in the courts, but it's also important with advocacy outside the courts. And then finally, I'll mention a couple of sample cases where a civil society organization sued a bus company and where the government requires the removal of assistance devices from pupils with dyslexia in Sweden, and what's been done in that case. Okay, this is my description of the basic problem. There's a man sitting on these boxes. I can't see any qualified applicants. And the boxes are prejudice, history, sexism, racism, self-image, denial. There are certain common issues in regards to discrimination, at least as I see it. And this picture gives a good definition, or a good, say, presents a good picture. And the big question is, how do you help him see? Or actually, how do you force him to see? And then here's another way of looking at the problem. You have the different interests talking about promoting equality or working against discrimination. But then you have both those who have power, the power to discriminate, and also the status quo is very heavy for requiring change, or a problem in regards to requiring change. And then in regards to requiring change, there's a picture or a statement from Martin Luther King. It's a sad historical fact that privileged groups have seldom given up their privileges voluntarily. One of the reasons I bring that up, at least from a Swedish perspective, is that there's some idea that change will automatically occur if you have a law, a well-meaning law, even if the law doesn't include sanctions. For me as a lawyer, that's a very strange idea, but it is something that permeates a lot of legal thinking or a lot of legislation that's intended to help people. It doesn't mean it permeates most legislation, but legislation that's intended to help people is based on the idea that we will somehow voluntarily help people or do what we're required to do without necessarily having sanctions in place. Another idea that at least I relate to the field of discrimination law is a statement by Chief Justice Earl Warren during the 1960s, said that many believe that you cannot wipe out racial discrimination by law, only through changing the hearts and minds of men. Said there's a false credo, prejudice cannot be wiped out, but infliction upon others can. And this applies not just to racial discrimination, but also to disability discrimination. And one of the key lessons was that if you ensure that discrimination costs or carries with it cost risks, people can change their behavior. But just because you want just because you ask for better attitudes, they will not necessarily change their behavior on that basis. Another idea is that legislation and litigation go hand in hand. Disability civil societies, disability organizations need to know what they want in the law, especially regarding enforcement. One of the reasons I bring this up from a Swedish perspective is that disability organizations were a key element behind the adoption of disability discrimination laws. At the same time, when you ask them, what kind of law do you want? They expected politicians and civil servants to produce a good law. And when I asked, well, what kind of law do you specifically want? They said, we don't have the competence. There are other experts who should be doing that. And if you're waiting for other people to do it, they will help. Both the unions and the employers' organizations and other interests, more powerful civil society organizations, they ensured that the law didn't have, say, sufficient enforcement measures in it, even if we have a law. And the importance of litigation is naturally that litigation can indicate the weaknesses in the law, leading to demands for change. And there's a question of enforcement by who, equality bodies, and or civil society. There's a question of the history of equality bodies. Sometimes there's confusion, at least in Europe, about are they civil servants or anti-discrimination advocates? And there's a question of whether or not they can be effective advocates, since they are also civil servants. At least we have this problem in Sweden right now. Part of the background is that in terms of US enforcement, the NAACP Legal Defense Fund was a key actor in ensuring that the US developed Fair Employment Practices Committees, the Civil Rights Act, and the Equal Employment Opportunities Commission. Eventually, that led to the adoption of the ADA, Americans with Disabilities Act, and the ELC got a disability mandate. At the same time, say, especially based on the NAACP Legal Defense Fund, other organizations developed or other legal defense funds were also developed at the same time. You have the Disability Rights Education and Defense Fund, DREDF. You have disability rights advocates in California that has also developed to help enforce the law on behalf of people with disabilities, because there was a realization that the EEOC would not be enough, that public interest lawyers were needed. And then you have this development within the EEOC. You can see that the UK developed the Disability Rights Commission in the 1990s. Sweden also got this so-called disability ombudsman during the 1990s. They had quite little power, but also they laid the foundation for the equality ombudsman, at least in Sweden. One thing, if you look comparatively at different countries, when there's a strong civil society advocacy in terms of both legislation and litigation, you develop what I would call a healthy competition with equality bodies, which leads to improved case law and improved implementation of the law, or at least finding out when the law doesn't work. If you don't have cases going to court, you're not going to find that out. And then basically looking at what's the purpose of an equality body. It's to provide some balance of power in regards to those with the power to discriminate. At least in Sweden, and I think in most countries, people who are the targets or subjects of discrimination or the victims of discrimination, generally, they lack the economic power to enforce their rights, even if they have certain rights that could be enforced. And those with the power to discriminate, employers, unions, businesses, for them, defending themselves in regards to discrimination cases, they can write that off. And at least in Sweden, if they can also threaten the, say, discriminated parties with the idea that they'll risk paying the costs of the winning party, which means that you can risk, at least in Sweden, you can risk paying, say, 200,000 crowns in legal costs. And at best, in many cases, the most you can get is 30 to 40,000 Swedish crowns, which means that it's very hard for people who are discriminated against to actually take those risks for such a small reward. One thing that keep in mind in regards to EU directives is the idea that at least the race directive requires the establishment of an equality body. EU law does not require the establishment of an equality body concerning disability, but many countries have leveled up the protection. And for example, in the UK or in Sweden, we have an equality body that is supposed to cover all grounds. If you look at the directives say that they should provide independent assistance to victims of discrimination. At least today in Sweden, where I think last year the Equality Ombudsman filed four or five cases in the courts, and they have a budget of 120 million crowns per year. It's hard to say that they're providing assistance to victims of discrimination, or it's at least extremely few. There's confusion about the role of equality bodies. Equinet, which is an organization for equality bodies in Europe, has pointed out these bodies have a distinct role from national governments and civil society organizations, investigating discrimination, building a culture that values equality, providing information and support to victims, monitoring, conducting research, engaging with public bodies, social partners, NGOs. My question here is, isn't that also the role of civil society organizations? And if it isn't, at least of some, shouldn't it be? And what are we doing to make sure it is? In regards to public interest law, whether it's NGOs or civil society or equality bodies, at least in terms of strategic litigation, it's important to have the right clients. Right clients meaning you want to have good cases. Sometimes you have multiple cases. If you have a lot of people being affected by the same problem, you can try to figure out should you bring it as a class action or use those multiple cases in a more creative way. Also, situation testing is proof. One of the difficulties in regards to equality cases is proving the cases. Sometimes you have to then develop, say, situation testing so that you can prove the case. In terms of, say, US cases that have benefited EU law, cases that have been taken on by civil society organizations, not by the official equality body in the US. You have the shifted burden of proof, indirect discrimination, harassment. All of those are issues that have been developed in case law in the US. And then we benefited by them.
You are viewing Paul.
What? Hello. Okay. Sorry. In terms of access to justice in Sweden, it's a question of equality bodies, unions, other NGOs, anti-discrimination bureaus, disability organizations, or private lawyers. You're going to hear a little bit later about legal aid, legal insurance. One of the big problems in regards to legal cases is who's going to pay for them. One idea that I at least mention on occasion is that this civil society organizations could be promoting is the idea of, say, like the Canadian Court Challenges Program, where civil society organizations were able to bring equality law cases financed by a government fund at the same time that they have a good equality body as well. And then the use of anti-discrimination contract clauses in public contracts. The reason that's important is that in order to increase the cost risks, many companies have public contracts. And even if you're not going to change the damages system in Sweden, if they risk losing the public contracts, they will think twice about what they're doing in terms of counteracting discrimination, promoting equality. One of the big problems in this field is say this picture. She's in a wheelchair. The reporter is asking, or somebody is asking the assistant, does she take sugar? And it says, no, but she studied disability law and she will sue you unless you speak directly to her. And this is a very nice idea. The problem is, at least today, there's not a whole lot of capacity in this regard. In regards to remedies, something you have to think about is what's the goal? In Sweden, we have a loser pays system, which means that individuals who want to bring cases and civil society organizations who want to bring cases, they quite often don't have the economy where they want to take on the risk of losing, which means that they can alternatively bring cases as small claims cases. That's not an ideal situation, but it's maybe better than nothing being done. And there's a question of whether or not a public sector lawyer can be a problem. Can they have the trust of the client? But also private lawyers, that's an important issue for them. Do they have trust of the clients? Then at least in Sweden, there's the issue of who has a right to bring an action. In Sweden, it is essentially only the victim who can bring cases. In other European countries, there are situations where an equality body can bring a case on behalf of the victim, even if the victim has not made a complaint. As the potential effects, that's why I brought up the issue of if there are many victims or potential for a class action, that also can lead to different effects in terms of media, in terms of having an effect on policy, et cetera. As to money damages, that's what we have to rely on in Sweden, essentially. And there's a question of equitable remedies, which you can find in some countries. It's maybe better if a court can order or issue an injunction saying that a company has to stop acting in a certain way or must act in a certain way. One of the issues also in a place like Sweden is that if only money damages are available, it is important on occasion to look at the issue of a settlement. If you've been improperly, or if you have been discriminated against in regards to getting a job, the best that a court can do is order the payment of damages or compensation, as it's called here. Whereas in a settlement, you can get the job as well, if in certain situations. Strong advocacy even outside the courts. This means press, demonstrations in the court. At least civil society organizations in Sweden haven't combined these ideas, have generally not combined these ideas. One thing is it's outside influence or media information in the media or demonstrations might, and I'm just saying might, affect the results in the court decision, or might affect the court favorably. I wouldn't guarantee it, but it is something that would be interesting if in a disability discrimination case, if the courts also all of a sudden have to accommodate a number of people with disabilities in the courtroom. This is not a normal situation, but if all of a sudden, say, no, I'm just imagining, but if you have 20 people in wheelchairs who want to go to a public trial, that could be interesting for the court, for the judges in general, for a variety of reasons. Another thing to think about is even if you lose a case, if it's a loss on the merits, advocacy can affect public opinion, can affect policymakers. Another thing about the outside use of social media, that can be a tool for fundraising for the case, and also a way of increasing awareness on the particular issues. Now, lastly, I'll mention a couple of sample cases, at least here from Sweden. There was a wheelchair user who was denied access to a bus. The driver was unclear about the accessibility that was available on the bus. The bus was accessible. The driver didn't know what to, driver claimed he didn't know how to make it accessible. There was a complaint to the Equality Ombudsman. The Equality Ombudsman decided not to pursue the case. As I understand it, they called up the bus company, and the bus company said, well, we won't allow this to happen again. But it had already occurred. The wheelchair user went to a civil society organization that agreed to sue the bus, sue on the plaintiff's behalf. There was a decision made that we'll also take on the economic risks in the case. We're not going to bring it as a small claims case. And eventually there was a successful legal judgment in that case. And then there's national school agency guidelines that require removal of assistance devices from pupils with dyslexia during so-called national exams. Here you have a situation where local governments are actually responsible for schools. Thousands of pupils are affected per year. It was decided that we would use, or that small claims cases would be filed in different regions on the same day. There was joint press conference, 2 cases lost, one was won at the trial level. The 3 appeals cases were lost. And now there's an appeal pending to the Supreme Court. At the same time, the Chancellor of Justice in Sweden has said that, well, the National School Agency is not responsible for discrimination because it is not an education provider as required under the law. A new case has been filed against the national government for violations of the Constitution, for violations of the European Human Rights Convention, as well as Swedish law, because the claim is that this National School Agency guideline is an instruction to discriminate. We'll see what happens in that case. That's about it for me. Again, the idea is that you need litigation in order to see that laws actually have, to actually see what the potential effects of a law can be. And then if it's done right, eventually we'll get to this picture. Now, how am I doing on time?
You're doing okay. We're a bit over time as we already started a little late. So I think we should be moving on the agenda. I'm hoping you will stay with us for the discussion, and perhaps we have some questions for you too.
Yeah.
And next up, we have Mari Silsal, who will give us an overview of the survey that was conducted on legal remedies globally. Please share your presentation, and I wish you very welcome to this talk.
Hello, thank you, Ola. So yes, as we said, I will put on my presentation. There you go. And yes, thank you, Paul, for a very, very good presentation. In conclusion, I could also say that we in the disability movement have seen quite significant progress sometimes if it comes to enacting new legislation that gives us rights for disabled people. We have witnessed the adoption of the UN CRPD and its ratification in different countries. We have seen the excitement of passing all the different legislation against discrimination in different countries. But as the excitement of the new legislation passed fades away, we can also see the relevance of what I choose to describe with this equation: law plus remedies equals rights. That in situations where the laws that give us rights are not followed, we kind of need a plan B. We need to be able to do something about it. Because when the laws aren't followed and we can't do anything about it, then the situation comes painfully close to a situation where there would be no laws at all. We just can't access our rights. It just doesn't matter what's written on the paper. So as we became more and more aware of these issues, we in the Independent Living Institute decided to carry out a survey on remedies. We would like to take a little peek into the world of different remedies, the different plans of P, that we and how these remedies are designed and organized in different countries. And today I would like to look at the survey report with you guys as well. So the survey had 6 questions to our respondents, and the first question was what country you come from. We had 30 respondents, and they, as you see on the picture that I'm sharing now, then the respondents came from 20 different countries, which gives us quite a diverse representation of different countries. But since we only had 30 respondents, when we are looking at the results of this survey, we have to be very aware of that we can't look at the results as statistical information because there are just so few respondents. We have to look at it as information with qualitative value. So the next question was a question of what remedies are available in your country. And the most popular remedies that are visible on the pie chart that I'm sharing now is the remedy of damages, usually monetary. Also the remedy of injunctions, as well as remedy of issuing an appeal. And another very popular thing is what here on this pie chart is called others. And this is where I would really recommend you guys to actually read the survey report, because there we could see some really interesting examples of systems of equality ombudsman or others that exemplify a little bit more creative ways of organizing remedies in disability rights. The next question that the survey was working with was, what are the things that are lacking in the remedies system in your country? And what the respondents then pointed out was that the payment of damages is too low to effectively remedy discrimination, which is also what, Paul, you were touching upon as an issue. The next thing is that institutions responsible for helping people to seek remedy are not active enough. They don't do their work properly, so people don't get support. Another thing is that there is a general absence of strategic litigation strategy in DPOs. Also, lack of political independence among DPOs is a problem in some countries, that if the DPOs aren't politically independent, then they can't always help effectively if it comes to remedying lack of access to rights for disabled people. And finally, there was actually more of a proposal coming up that there should be established some easy access, low cost bodies, which would have legal decision-making power, so it wouldn't be so incredibly difficult for people to get a legal remedy. And another thing that the survey was discussing was actually the issue of what exactly deters people in your country from taking court action. And the pie chart that I'm sharing now shows that one of the huge factors what holds people back from taking court action is high financial risk, which is again another thing that Paul actually also touched upon, that if you risk to having to pay the other party's litigation costs when you lose in court, then you might not really want to take the risk. But another thing is that taking court action can take a lot of time, which people always don't have. And one third thing that was pointed out quite a lot was lack of knowledge among both disabled people, but also other actors that are supposed to contribute to the process of using legal remedies. Finally, the last question that was asked from the respondents was, should the discussion on remedies continue? And there we got an overwhelmingly positive answer from our respondents. Everybody was thinking that the international disability rights community should continue discuss remedies and how to make them more effective in our work towards disability rights. And there were also some other topics pointed out which may go beyond the discussion of remedies, but are also very, very important if it comes to organizing access to remedies. And these issues are access to justice in general, then also training for lawyers and DPOs, development of law clinics, as well as awareness raising on human rights and disability rights more in general. So I really hope that the discussion on remedies will continue from here, so that we can discover better ways to find remedy for breaches of rights for disabled people. I will also put a link to this survey report into the chat box, so you guys can find it from there. And yeah, you are very, very welcome to contact us also after the webinar if you have any questions about the survey or would like to continue the discussion somehow. Thank you.
Thank you, Mari, for your talk and the presentation. Now I would like to invite Anne Campbell from Validity to the floor. Will you be sharing a presentation?
I will not, because I don't like slides very much. So I'm just going to talk to you guys, if that's all right.
Excellent.
Super. So thank you very much for giving me some space to speak today about this really extremely important topic. What I would like to speak to you a little bit about is the connections between the violations of rights that women with disabilities experience and the options and opportunities for remedies and redress offered by the international torture law framework and how that looks like in national law frameworks. Because I think, in my view, that it opens up a lot of potential remedies that are not traditionally used by people with disabilities, including it also offers ways of potentially tackling institutionalization and access to services and supports in the community. So I think most people here are familiar with the types of violations that women with disability experience, but let me just set out a little bit the sorts of things that I'm talking about when I'm talking for the next 10 minutes or so. Obviously, women with disabilities experience all of the same violations and violence as men with disabilities, but they also experience gender-specific violations. These include, for example, domestic violence, sexual violence, including in institutions and group homes, and a range of violations of sexual and reproductive rights, including non-consensual sterilization, forced abortion, and on the flip side, denial of access to abortion, physical and gynecological examinations without full and informed consent, denial of pain medication during menstruation, forced and non-consensual contraception, and on the flip side, denial of access to contraception, and various forms of humiliation, such as in Hungary, we met a teenager in an institution who was forced to wear diapers instead of being given access to feminine hygiene products. Or in Moldova, we met a young woman in a psychiatric hospital who was tied naked to a bed in full view of everybody else on the ward. So to me, from a non-legal perspective, many of these acts alone or together can be called torture. And there is law internationally to back that up, to back up that claim. The definition of torture in Article 1 of the UN Convention Against Torture includes 4 specific elements that you have to prove in order to prove that somebody's been tortured. First is that they've been subjected to severe pain and suffering, and that is analyzed from the subjective and objective point of view. So both, did the person experience the act as severe pain and suffering, and from an outsider perspective, does it look like that's what it was? And pain and suffering is both physical and so-called mental suffering, which is psychological or emotional suffering. And it can be that if you've been subjected to 4 or 5 different types of violations, sort of so-called small violations that are forms of humiliation, that alone they might not objectively look like they give rise to severe pain and suffering, but actually together the effect can be very, very severe for the person experiencing it. The second criteria that you have to prove is that what happened to you, or the act that was inflicted on you, was inflicted intentionally. That means that the person did it with intent, not to torture you, but to actually do what they did. They were conscious of what they were doing. The third thing is that it must have inflicted severe pain and suffering intentionally for a specific purpose. And traditionally, that is understood as extracting a confession from a prisoner, for example. But actually, the convention lists a number of other purposes, including for the purpose of intimidating somebody or coercing them to do something, for the purposes of punishing somebody, or for any reason based on any discrimination of any kind. And the fourth criteria is that you must be subjected to severe pain and suffering intentionally for one of those purposes by state authorities, or with their acquiescence. So they have not stopped it. many of the violations that I spoke about at the beginning, for example, forced sterilization, these are inflicted intentionally. The level of pain and suffering emotionally, psychologically, and physically is very severe. Measures that are taken in group homes or in institutions are often taken to punish the person for breaking the rules of the group home or the institution, or to control their behavior by intimidating them into following the rules or coercing them into following the rules. Many measures such as restraints or forced medication are discriminatory because they're either exclusively or disproportionately applied to disabled people. And when the last criteria around it must be done by a state authority seems like it might be a limitation, but there's actually quite a bit of case law that suggests that if a private actor carries out these acts, so a private institution or a carer in somebody's home or somebody providing a service in a private support service, daycare center, for example, the state has an obligation to carry out due diligence to prevent those sorts of violations. So, for example, before the European Court of Human Rights, there have been a number of cases where somebody was beaten or murdered by their spouse in their house, and the court was found, the state was found liable under Article 3 and the prohibition of torture and ill treatment because they didn't take effective measures. They failed to take effective measures to prevent the murder or the violence, and they didn't take enough steps to provide a sufficiently deterrent effect to stop the person from doing that. Now, one of the reasons that I think the prohibition on torture is actually a very interesting lens for lawyers to look at when they're talking about the remedies for people with disabilities is because it opens up access to the international redress framework. This framework looks at redress for victims of torture from a really wide angle. So it looks at 5 different types of remedies or redress that can be accessed. One of or that should be accessed for people who have been subjected to torture. One of them that I think is crucial is the remedy of satisfaction, it's called, which is essentially about recognizing that what has happened to the person is a form of human rights violation and a form of torture and an unlawful act. And I think because of the types of violence that women with disabilities are subjected to regularly are not considered crimes or even human rights violations, the requirement to recognize these as torture and as unlawful can be an incredibly powerful tool. I'm thinking particularly, for example, forced sterilization, just as one of the ones that comes to my mind straight away. So many women with disabilities are forcibly sterilized without their consent, without talking to them, without any notice being given to their opinion whatsoever, and yet everybody thinks that it's quite normal. Whereas in fact, the torture framework can be used to compel courts to recognize that that is unlawful. It also can be quite powerful in terms of recognizing that institutions are actually places of detention. So if you can make the argument under the torture framework that rape in an institution is akin to rape in a place of detention because the person can't get out, then you can make the point that institutions are not by choice, but people are forced into them and they are unlawful as a result. The second element of the redress framework that I find particularly interesting for lawyers to look at in this context is the requirement for the state to ensure non-repetition of the violation. So once you have shown that you've been subjected to torture, there's an obligation on the state to ensure that you are not going to be subjected to it again. And this to me is very interesting, I think, because it requires the court, sorry, I keep saying the court, the state, to make sure that they take measures to create an effective deterrent for people, private actors, so that they don't do this again. And that includes things like regular monitoring of institutions, of service providers. There must be a genuinely effective complaints mechanism. But in addition to that, when a prisoner is tortured in prison, there's an obligation to remove the prisoner from that prison and to take them out of the environment where they've been subjected to torture. And so the question arises for me, is there also an argument that a person who has been tortured in an institution must be removed from that institution and placed in a place where they will not be at risk of the same thing happening again? And in my view, there is quite a strong argument that can be made on that basis. The third element of the redress framework that I think is very relevant is that people who have been subjected to torture are entitled to rehabilitation as a form of redress. And I think in the context of women with disabilities and people with disabilities in general, this rehabilitation must be disability sensitive and disability specific. And there is a possibility there of looking at litigating that entitlement to rehabilitation, to access adequate and effective supports and services for people who've been subjected to these sorts of acts. The other two elements of the redress framework, because there are 5, are restitution and compensation, but I think that they're less relevant. The previous speakers have referred to some of the limitations around compensation, for example. So I won't highlight those anymore particularly. I just, I guess, want to briefly finish up, because I know that I don't have very much time, by saying that in national jurisdictions, the international convention, the UN Convention Against Torture, requires states to have a prohibition on torture at their national level. So most states do have that as a crime, and using the criminal law it can be quite an effective way of trying to highlight these issues. Even if the country doesn't have an explicit prohibition on torture, they will have other forms of law that they use to litigate torture and that are used by so-called, against traditional torture cases. So have a look at those and see what is available. Most countries also allow you to apply for interim measures during litigation. For example, for release from a place of detention or for immediate access to medical or psychological or social services. We've done that in Hungary, for example, using an Axio Popularis process, and we've had some limited success with it. But also look at victim support services for victims of crime generally and victims of torture specifically. While many don't cater for people with disabilities explicitly, they actually have expertise in relation to psychosocial disabilities, even though they don't use that term. So working with them and making allies of them and capacity building them to provide services to people with disabilities it can be quite beneficial. Also research what redress schemes exist for victims of torture in your country. There may be existing schemes, or there may have been schemes set up for certain reasons. For example, I'm thinking in Ireland, a scheme was set up for compensating sexual abuse of children in schools by the Catholic Church, or in the Czech Republic, a scheme was set up for to compensate victims of sterilization in the Roma community. And these schemes are often available without having to prove the fact of torture to this, or at least not to the same level as in a court. And if they don't exist, consider what systematic violations might be susceptible to advocacy to create that sort of a scheme or a public inquiry. And then lastly, also look at considering using civil law to litigate positive obligations of states to provide redress for victims of torture. There are lots of pros and cons to that. I think some of them were touched on earlier, and so I won't go into particular detail, but we are taking that avenue in Moldova, for example, crafting a case for access to social services for our client as a victim of torture and of trafficking. We're also taking that avenue in Uganda, looking to craft a case for access to sexual and reproductive rights information and counseling for our client as a victim of rape in an institution. So that's what I have to say for now. I'm open to questions later, of course, and feel free to reach out to me individually if anybody's interested in more. Thank you.
Thank you very much, Anne. It was very illuminating, I think. We're getting closer to a much broader picture now regarding different kinds of rights issues and what different kinds of remedies might be useful and effective. But I think before we move on, we should take 5 minutes or so of a break that we promised. So I suggest we see each other back at about 3:15 CET. And then we will be talking to Stellan Gärde and Timothy Hodgson about more interesting things regarding the right to legal aid and litigating economic and social rights. So I'll see you back in a few minutes. Thank you so far. I see that the clock has struck 3:20. So I give the floor to Stellan. Are you ready?
Yes, I'm ready. Yes, I asked, hello friends, I'm a litigating lawyer in Sweden, and since last years, before I made many cases related to labor law, and was in the very good position that all the cost of cases were financed for each members of the trade unions by the trade union. So there was by the membership, they had a free access to litigating lawyers and also negotiators and so on. But when you come into the area of disability and the area of civil courts and administrative courts, it's obvious that the biggest difficulty for access to justice today, I find in the costs. If there were positions for funding, or in any other sense, the possibility to access to court without being afraid of a lot of financial cost, it would be a very big difference for the people involved. And but I will just go. Did you have the text I gave you, Ola?
Yes, I can share it with everybody.
Okay.
So just let me know when you want me to shift something.
Yeah, good. It's the first page. I just like to cite the on the top. In Article 6 in European Convention on Human Rights, you have the right to a fair trial regulations, and there is the most important part of that, or at least a very important part of that, is the right to fair hearing. And this regulations has been interpreted in that way that it's also if there's a huge imbalance between the parties. So if you have one person who is private person and you have a case against the state or the local community, we have lawyers employed and have enough resources to engage lawyers that they always do in court cases. Then, and if you have no access to legal aid, you will not be in balance. Equality of arms, you can say there is no equality of arms in that situation. And actually the European Court of Human Rights has taken some cases, and if you take the next page, Ola, we'll go down to the second page. There are some cases, and one very obvious case was Steele and Morris versus the United Kingdom. It was two people that belonged to Greenpeace who were in court against McDonald's. And McDonald's argued that they were liable due to their participation in a Greenpeace campaign against the company. And in the case, these two persons were not given the right to legal aid by the state. And just for taking, the court found that it was not, the balance between the parties were not in any sense equal. Just in the first instance, there were 313 days of trial, and they didn't have the possibility financially to have the cost covered for their lawyer. And the court said the parties had completed different conditions for bringing their action, and the lack of legal aid in the case meant that the defendants did not have a fair trial. And I think it should be, I don't know for sure that everyone looks at this as a human right, but it's actually a very basic human right that legal aid should be given in some cases. And also the second cases I will just further below, Ola, it's a PCS versus United Kingdom, and it was parents who had a case where the of involuntary custody of their children, and of course that was is a huge complicated case and of great interest for the parents, and even that when they were given any legal aid from the state, there it was found that was violated the right of fair trial. The third case was defamation, and that was not that kind of case that the court found was in breach of the fair trial regulations. In Sweden, when I have represented some clients, I have one client who is named Dick. He was on the national television the other day for last week for his situation when he was very ill-treated in institution. His disability is in that regard that he is on the age of 4. He's about 40 years old, and but he's mentally on a four-year-old child position, and he was not given legal aid due to that. They said that he had a trustee who was not a lawyer, and only his grandmama, and she had no legal experience at all. But the courts did say, according to the Swedish system, she would be able to, with the support of the court, to do all the cases, his case. And this case was going up to 2 different levels, and was a lot of oral hearings and a lot of witnesses, and also a lot of interpretation of the law and so on, and court cases and so on. And for me, it was obvious that she were not able to do the case. And this was in the administrative courts. And in Sweden, it's 98% of cases they don't give any legal aid in administrative courts, and a lot of cases are administrative cases due to disability, the right to different assistance from the state and so on. So I believe that in this area where you have a disability, where you can't defend yourself in any sense, and you need a lawyer, there should be obviously a general rule to say that this area of the law that there will be free legal aid. And in the administrative court in Sweden, even if you win the case against the state or the local community, you're not giving any support, you are not covered your cost anyhow. So next week, we will take, this case has been going up to the Supreme Court of Sweden, Supreme Administrative Court, and next week we will take the court to European Court of Human Rights. And I believe there is a need for the area of disability to be very active to ask for and demand legal aid in their cases. Normally, it's very, very difficult for them to represent themselves, and the need of the law is very complicated many times to make a case in the court. And even if you go to even you go to the civil courts, it's obviously that in general you can say that if you are going to have effective human rights, as any convention has as a base for any human right, that they have to be effective. And if it should be, the only way to make them totally effective is to also offer the possibility to take the case to court. And if there is no possibility for legal aid in human rights cases, and in Sweden, it's very, very difficult to have human rights cases and legal aid in general, even civil courts. And even if you have legal aid according to general state scheme, it's obvious that you will have a problem with if you lose the case, you can have a cost for $500,000, both for your own cost and for cost for the opposite party. So I think when it comes to basic human rights, I think that one should argue very strongly that are funds developed in order to for people who are obviously where the cases of human rights are violated, there should be a possibility to have the legal aid either by a state scheme or a private fund scheme to see to that human rights are effectively protected. So I take any questions later on this matter. Thank you very much.
Thank you, Stellan. It's really interesting to see more, in more cases how the access to justice matter is so central to actually using your remedies. And our final speaker before we go into the discussion is Timothy Hodgson. I welcome you to the floor. Will you be giving a presentation?
No, I don't have a PowerPoint.
Yeah, that's fine.
Also, I think the least Swedish person in this conversation, which is no problem for me. I am in South Africa. I am South African. I'm sitting here in Johannesburg. I work for the International Commission of Jurists. The International Commission of Jurists, for those of you who are not familiar, is an international organization, which is a human rights organization, but at the top of it sits a secretariat of commissioners who are mostly judges, very senior judges around the world, sometimes academics and other lawyers. And we work towards promoting the human rights and rule of law all around the world. My speciality is economic and social rights. And I think that what Ola wanted me to speak about today was both economic and social rights, but also connecting it to remedies, which is really a theme which we've discussed, and disability litigation. What I wanted to do to start off with, before I'm going to talk a little bit about domestic, social, and economic rights litigation. But first, let me say, so that we're all on the same page, when we talk about economic and social rights, we are talking about the right to work, the right to housing, the right to healthcare, the right to water, the right to education, the right to social security, and so on and so forth. We are talking about rights which classically are considered to be issues of policy for how the state will improve society and the welfare of society. And in different countries around the world at different times, governments support different programs for this. And the question is really, what is the role of the courts in ensuring that people's welfare is protected? So in the international human rights language, in ensuring that the economic and social cultural rights of people are respected, protected, promoted, and fulfilled. So that's what we're talking about there. And then when we get to remedies, I just wanted to say this because it hasn't been mentioned. From an international law perspective, there are principles. So there are UN guiding principles that have been endorsed by almost all countries in the world in 2005 on remedy and reparation. I won't go into detail about it. You can find it online, or I can provide it to you, but these principles apply to all states. And they apply to all areas, including the realization of social and economic and civil and political rights. They obviously apply to situations involving the Disability Convention too. And that means that there's an entitlement to an effective remedy, a right to an effective remedy, which includes restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And you'll see when you look at even the recent case, which Ola sent to me, I think it's the Independent Living Institute, the Swedish case about the person with the deaf man who could not get a job. I think that's correct. Was discriminated against by the university. The Committee on the Rights of Persons with Disabilities follows really this list of remedies that it provides: restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition, and generally makes orders and provides remedies that follow all of those things instead of merely providing a declaration or an amount of compensation. So it's worth taking into account. Also, what's been discussed already today, and I don't want to underestimate it before we get into the specifics of how there can be remedies for socioeconomic rights cases. And it's a very important thing that people miss. Sometimes we get stuck up in the substantive legal principles. So what does reasonable accommodation mean? What does accessibility mean? What does reasonableness mean in a test of whether a government policy is reasonable? Procedural law and legal procedures often dictate the availability of remedies. So in almost every single country where there's effective litigation on social and economic rights, you will find courts have adopted procedural measures which allow for that. So for example, one of the big problems that has been raised here is legal assistance. Another one is costs. So in South Africa, for example, if you are a not-for-profit organization and you make a bona fide argument in a court, so one that's not vexatious, there is a legal rule set up by the courts that you cannot have a costs order against you. You can never carry the costs of the other parties litigation, because you are litigating in the public interest. One major thing. A second thing is standing rules. So allowing for organizations or NGOs to litigate on behalf of categories of people, whether as a class action or in public interest litigation. In India, in South Africa, in Colombia, in all of the countries where you find a lot of litigation for welfare rights, for social and economic rights, you find these procedural rules have allowed for that. What I can say in general before I start out is that in Sweden, if you look at the most recent recommendations of the Committee on Economic and Social Rights, the UN committee, repeatedly, the committee recommends to Sweden to ensure that the rights in the international covenant to which Sweden is a party can be domestically or domesticated through being put in legislation so that they can be litigated directly. So what is socioeconomic rights litigation and how has it happened in South Africa? Because I'm using South Africa as a case in point. There are other countries though. Actually, most countries in the world, most constitutional democracies, some form of social and economic rights litigation can happen. All of the rights that I spoke about, the question is when they are deprived by a person, and by definition, if you're a person living in poverty, and there are people living in poverty all around the world, then you are very unlikely to have full access to economic and social rights. So it's there's always a litigant. The question is, how can the litigant find the court? And we've discussed all sorts of problems and hurdles that have happened on the way. Those hurdles are even bigger in the disability community. Now, the reason why they are often bigger in the disability community is that it is this classic separation between a social or human rights model and a medical model. So very often, the disability advocacy community in many countries around the world, it's not every single country, is separated from the human rights community or people advocating for other quote unquote mainstream human rights issues by virtue of the fact that it is considered something else, something separate. And the separation happens even in legal advocacy and in legal communities. And you often find human rights lawyers who are only doing disability work, and then human rights lawyers who are doing everything but disability work, and they're separated. But this happens in South Africa too. and it's very hard to explain other than for this way of thinking about the world. But with social and economic rights litigation, the typical situation is you have a person living in poverty. They are being evicted from their house, or they are being dismissed from their job, or they are not being able to trade in a situation. They might be a foreign national, not allowed to trade, not being given the documents required to trade. Or you have a person who, in the situation of a child with a disability, is being denied access to a local neighborhood school. And that person comes to a lawyer, normally a not-for-profit lawyer, because they don't have money, and says, what can we do about this? Now, the typical problem that's been raised around the world is, well, how can the courts dictate to the government what to do? And the core of social and economic rights litigation is to say, although the courts can't make policy decisions for the government in any country in the world, and that's not a good idea because judges are not well placed to do this, the courts can say whether a basic level of adherence to human rights protections has existed in a policy or a law, either in its formation or its implementation. They can say whether or not that law or policy is discriminatory. They can say whether or not it is being considered to be reasonable. And the standard to determine whether or not the government has taken sufficient measures to progressively realize all of these economic, social, cultural rights in a country like South Africa has been for courts to say, we will just tell you whether or not the measures that you've taken are one of the reasonable options you could have taken. So to give you a silly example, there are many ways that you can respond to COVID around the world. But a court might be able to say it's unreasonable to say that COVID-19 is a Chinese virus, which is being brought on us by other people, and wearing a mask is an inhibition of your freedom, as we see in some places in the world. It's not that the court will say this is the best policy option, but it will say to the government, well, you've considered this, which experts have you consulted? Is it based on rational evidence? And is this something that you could have come to as a conclusion? Is it a reasonable conclusion? And this is how this litigation works. Socioeconomic rights litigation is also aided by the fact that there are international standards for a minimum core or a minimum standard of each right which everyone is entitled to, and the standard that retrogression, so moving backwards in access to housing or education or water or any of these materials, is not permitted on the part of states who are bound to the covenant. And so very often what you can do is say that we're not even getting into the debate about whether or not you've chosen a reasonable policy. Why? Because you haven't even provided the minimum amount of access. Now, when it comes to persons with disabilities, this is normally the case. Normally the problem is that there is simply not adequate consideration of persons with disabilities needs in a policy about education or healthcare or housing, or if it is, it's not implemented in a way that is reasonable at all. There's very little effort. Sometimes, and this is a question which always comes up, resources are mentioned. So when an accommodation is asked for a person with disability, or where more generally persons with disabilities ask, well, why can't we be accessing the same schools, the same healthcare institutions, the same housing as everyone else? The government will say that there is no money. That is, in socioeconomic rights litigation across the world, a permissible defense from the government. But I can tell you, in my experience, in almost every country, in almost every court case I've ever seen, a government claiming a lack of resources has never been able to illustrate a lack of resources. Why? Because once a court simply asks, put up information explaining why there is a lack of resources, everything suddenly goes silent, right? So a local government will not want to disclose its budgetary information because almost always governments are spending money on things that they don't need to spend money on, or wasting money, or not bringing in as much money as what they could bring in. And governments don't like that scrutiny. So when you litigate, you shouldn't fear the government claiming a lack of resources, because most often they're not even going to explain why they lack resources. But even if they do, courts shouldn't be looking at the minutiae of budgets and determining what the government should budget or what the government shouldn't budget. But for example, if the Swedish government tomorrow said it's not going to budget a single cent for education next year, you would understand that a court might be able to do something about that, because it would be obvious that to a judge that this is a court, that the government that is not taking education seriously, that is not actually taking positive measures to respect, protect, promote, and fulfill the right to education. I've given you these examples. I haven't used specific cases, but there are many, right? There are many cases relating to disability and not to disability in countries across the world about challenges to policies to get the policies struck down or changed, or challenges to the implementation of policies, challenges to discriminatory policies, challenges to the government's non-initiation of a policy in the first place. So you might have a country in which there are no measures taken by the government to provide housing for homeless people, so shelter and housing, or victims of domestic violence. And then you can say, well, there is a positive obligation on the states to plan for that. And the remedy you ask for is the creation of those housing settlements or whatever the case may be. I'll just talk a little bit more to remedies. You also obviously need a court system that is amenable to the creation of creative remedies. In South Africa, the Constitution says that a court, in determining the constitutionality of a certain law, policy, or action, can make any order which is just and equitable in the circumstances. Now, that's a constitutional direction, which the Constitutional Court has said requires them to innovate and create different remedies in different situations. It's also a direction that you could produce out of the principles of international law if you were a judge who wanted to do that, or out of the principles of natural justice, that it's obviously the judge's job to ensure justice in a particular situation, and specifically when it's human rights claims that are being made, and judges should try and interpret their powers broadly, although not too broadly to be inappropriate in their function. And one of the things that you realize from social and economic rights litigation, when you see it practically, there is very little a judge can't do when a case is argued properly and the correct information is in front of that judge. And one thing which judges don't do enough in these cases when they are claiming that they can't make decisions about social and economic rights and they can't make orders is that they are not insisting on information. And simply by convincing judges to insist on the state providing evidence, experts to be providing evidence, is normally half of the battle won in this type of social and economic rights litigation. But the orders, and as you've already been discussing today, can be anything along these lines of the international principles on remedy and reparation. It can be financial damages, but depending on the circumstances, that may be very effective or it may not be very effective at all. They can be declarations of illegality. They can be structural interdicts. So sometimes what the court does in South Africa is it will say, the government has taken 20 years and it's done nothing to produce social housing for people. There is no reason for us to believe that if we don't require the government to report back every year about this, that it is going to continue to change its ways and produce results. And so then the court creates a mechanism through which there's a report back. In some situations, and in some other countries it's happened too, but the court can appoint a special master, an administrative position, right, which is an administrative body that will be required to observe the implementation of a judgment. This is very common in India and has happened on litigation to do with the right to food. In Colombia, what the court has sometimes done is said that these violations of a specific right, so in a classic context in the Colombian situation, the right to healthcare is so common that we will allow people to come to court and just get a declaration of their rights, which then can be disputed by the government. So you get a declaration saying that you have a right when you go to the clinic to get X medical service, and it's not being enforced. In Sweden, this is probably less of a problem, except for looking at the details for marginalized and disadvantaged groups of people. So Sami people, Roma people, ethnic minorities, etc. And discrimination litigation across the board is always important in socio-economic and economic rights litigation, because it's always discriminated against minorities who have the least access to economic and social rights. The last thing that I wanted to leave you with is also that the question, if you are working in disability rights advocacy, if you are not working with hand in hand or ensuring or demanding support and allegiance from activists in mainstream civil society, even opposition political parties, any entity that's politically active in moving forward a society. If there is that separation between disability advocacy and other human rights advocacy, which I've identified, then it means that the segregation of persons with disabilities from mainstream society is playing out in the activist environment. And if that's happening, you can't be very surprised that when it comes to courts and litigation and remedies, that gains for people who are not disabled are happening quicker than gains for people who have disabilities. And this is an unfortunate and terrible thing that happens in South African civil society too. And I think I explained this to Ola the other day when we had a discussion. You'll have a situation where there's a problem with access to textbooks for an entire province of people. They're not getting the textbooks they need to study for school. And then you have litigation, which demands access to textbooks. Only for 3 years later to have for example, blind children litigate again to get access to Braille textbooks because they still don't have access to their textbooks. And really, I can't encourage enough for the strategy to be the complete mainstreaming of disability rights in any and all advocacy for the improvement of social welfare in society. And I hope that I've created an overall general idea about how it is that a court might be able to both determine whether a violation of economic and social rights has occurred, and then to provide some kind of a remedial action for it. And obviously, the remedial action will depend on the circumstances and depend on the right, but it's about crafting something which is effective, that gets the correct government response, as well as make structural changes, as well as providing reparation to a particular individual or group of people.
Yes, thank you very much, Timothy. I think one of the main lessons here is that we need to pursue procedural frameworks parallel to the material rights, because without the procedural frameworks to enforce the rights, it's really hard to claim that they are effective and even actually rights. I think we have a few minutes now, not many, for a brief discussion or actually questions to the speakers. And I see two hands. Please keep the questions brief. First one up, we have Amos of Faith Becky. We can't hear you. Are you with us?
Can you hear me now?
Yes.
Yeah, okay. My name's Amos Faith Becky. I actually I work as a caregiver, and I'm a student in the University of Yale studying international social work. And I'm also a mom to an autistic boy who is 24. And following the discussion, like what the last speaker just said, the courts sometimes they just tend to ask very little information, because I can as well see my son's situation not only as racism and discrimination, because sentencing Emmanuel to indefinite compulsory psychiatric care because he has an outburst, and the police was called, and the police officers went ahead and pressed charges, means you're sentencing Emmanuel for being autistic, mental and intellectual disabled. It means Emmanuel on his part had a choice, but choose to be autistic, which I don't get it. And then before the sentencing, we were sent for forensic psychiatry evaluation, meaning that an autistic person, there are times you can be autistic and there are days you cannot be autistic. I don't get the picture, because my same son was knifed. And when we went, I tried to press charges, and I was told that he doesn't have the psychological capacity to witness or to explain what actually happened. Then now is like something like a systematic torture. And presently, we talked about forced medication. If you look at my son, the situation is it's so pathetic. He's been forced on medication. He's been locked up. He's been beaten. He's been belted for not following the rules and regulation. And we know that this is autistic people have this tendency of they have a problem following rules and regulation. Then you're punishing, you're belting, you're locking him up in a notorious psychiatric center meant for psychopath. This is not somebody who is a psychopath. This is an autistic person that was born autistic and is going to live his life. So it's just complete punishment. Even I don't know where to turn to. When people ask me on media, Becky, can we raise some funds for lawyers? I don't even know where to turn to. I said, I don't know. I cannot tell you guys. I don't want to collect anybody's money because I don't even know where to turn to. That's my question. I don't know.
Yeah, I think your remarks really show that sometimes it's hard to know what remedy would be useful, if there is any, in the country.
Yeah.
And this is a perfect example for where we need legal aid schemes, so that you can have access to a lawyer to go through the case and try to find these legal, well, revenues for change or
Have
actually.
you been in contact with civil rights defenders?
The point is, you make contacts with a lot of. I've made contacts with Autism and Asperger Forbundet. I've made contact even with Olalinda. I've made contact even most often. I make contact with Autism Society in the U.S. or
I
advocacy.
didn't ask about them. I asked about civil rights defenders. I know they're
Yeah, of
taking.
course.
Wait,
I've
I know
contacted
they're.
Olalinda.
Okay.
Yeah, I've contacted you.
Yeah, I don't want to go into the case now in this open space, but perhaps we can move on to the next question also. Dag, do you have a question?
Yeah. Thank you very much. Can you hear me?
Yes.
Okay, great. Thank you very much. My name is Danyacho Wakini, and I'm a doctoral candidate at the University of Pretoria, working on violence against persons with disabilities in Africa, a case study of Ethiopia. And I'm a person with disability myself. I have a couple of questions and one comment, very brief ones. The first one is a question to Marie regarding the report, the survey report on remedies. So this issue of equality bodies, has it surfaced in your survey by any chance? How prevalent they are, how present they are all over the world, or are they more vocal and available in the West or in the North than the South? That is one question. The other one, again, is related to the survey report, and that is the issue of lawyers with disabilities. Did you by any chance have any response indicating the relevance of having lawyers with disabilities, empowering persons with disabilities to get involved as lawyers, and also assist in curbing the status quo of discrimination and violence? So these are the two questions. The last one is a comment regarding the issue of torture. I think that was a presentation by Anne Campbell. The ICCPR and the Human Rights Committee General Comment 20, I guess, on Article 7 states that this requirement of involvement of public officials is not necessary. It's relevant in order for torture to be defined as torture. So we do have an authoritative interpretation regarding that, indicating that the presence of public entity or public organ is not necessary. I just wanted to highlight that. Thank you.
Okay, thank you. I think the question was directed to several people. Who is open to answer first? I think it was to both Mari and to Anne.
I'm happy to just briefly respond to the point on torture, which is a very, very good one. Absolutely, there's difference between the way that the ICCPR deals with it and the way the CAT deals with it. There's also differences between the definition of torture and the definition of inhuman treatment under CAT. Inhuman treatment doesn't require the participation of a state official directly either. But I think also, and probably most important for this webinar, is to look at the national laws that are in place in your own jurisdictions for this question, because many national laws have domesticated the CAT convention or the torture definition in different ways. And some are wider than the actual Article 1 definition that I was speaking about. So for example, in Uganda, they have enacted an anti-torture act that includes that doesn't require state involvement, and also includes a really long schedule listing the types of things that the Ugandan government considers to be torture, including things like non-consensual medication, for example. Though of course it's always more complicated on the ground than it sounds on paper in relation to that. But yeah, it's a really important point that there are the different ways that the legislation is domesticated, and the different international bodies and the way that they interpret it mean that the requirement of state obligation is not always as clear-cut as it seems when you read it first. Sometimes there's quite a lot of wiggle room around it.
Thank you. Mari, do you have a reply too?
Yes, I do. I would like to address the first question first about the equality ombudsman and how prevalent they are in the world according to our remedies survey. Yes, the remedies survey did discuss the topic of equality ombudsman, so it is worth it to read it to learn more about that. Specifically, there was discussed the Swedish example of equality ombudsman, and both the good things about it, but also the shortcomings of the equality ombudsman system, like for example, like some lacks in legal powers for the ombudsman and this kind of things. Now, when looking at the issue of prevalence, then we have to really remember that the survey did not cover the different countries in the world very well. We had only 30 respondents, which is way too little to make any conclusions about prevalence of something. But it did indicate that there is this kind of a system of having an equality ombudsman is used. Now, if it comes to the second question about the need for disabled lawyers in the litigation to kind of combat the status quo in the lawyering area, then that question was, I don't at least remember that would have come up explicitly in the survey. However, the independent living movement, of course, stresses the point of having disabled people promoting their own rights in as many areas as possible. So the independent living movement, of course, does really stress the point that if we are going to have effective litigation systems and effective representation of disabled people, then of course lawyers too have to be people who have their own experience of being disabled themselves. Thank you.
Thank you. I think we may have one final question from Kapka, and then after your question, we will have some final words to end the webinar. You need to unmute, Kapka.
I will have a very quick question, and it is related to CRPD and its implementation on national level, particularly Article 19 and the way that disabled people are provided with personal assistance. There are many countries where governments say we have personal assistance, but actually it's far from the from what the CRPD prescribes. So is there any possibility to have a court case or a legal case of violation of CRPD if a personal assistance is not provided the way that that it is prescribed in CRPD? And I want to thank everybody for this brilliant webinar and for all these people who I see here, which doesn't happen very often, and it's very helpful. Thank you, guys.
Thank you. Is there any of the speakers who would like to address the question?
Yes, hey. Money.
No, I don't hear anybody. Tim, you have your hand up, so I'll give the word to you.
Yeah, I wasn't on that. I mean, I think that what Kapka is asking is a very good question. I think that you could litigate on that. And I think that the reason why it would be important to is that for conventions and for human rights instruments to exist, you have to really cut down language to a very small amount. And then those words always need to be given meaning, right? In my environment, when someone says you have a right to education, then the question is, it doesn't talk about schools, it doesn't talk about teachers, it doesn't talk about how good the teacher must be, whether the teacher must be qualified in a certain way, etc. And the same thing with support workers. You're going to need to give definition to it, because otherwise it's open to interpretation by governments. And normally, even if it's not with disability, it's as often abuse as neglect. Just absolutely no ability or knowledge. I can tell you in South Africa, for example, just to give you one example of a support worker, orientation and mobility instructors are needed for blind people and for some other persons with disabilities to be able to navigate the environment. But the government doesn't produce any formal training process to train these people. It's not an acknowledged profession. So it's only happening informally within the disability community. And so then obviously the standards can be complicated. There's too few people, they don't get paid enough. It's not like with doctors or OTs or things like that that you can regulate. So I think that litigation would help even the government probably to refine its own mandate. The point that I wanted to make, and it's coming back to the question that was asked first by, I think it was, maybe it was Amose, but your child's situation is obviously horrible, but unfortunately common all around the world because of the way that institutionalization is a preferred method of dealing with disability. Now, I've posted a link here to recent principles produced by the Special Rapporteur, the UN Special Rapporteur on Disability, which are attempts to try and ensure that people with disabilities can be involved in their own trials, in accessing justice. And those principles would be very useful to advocate on in any country to try and get the government to think about the reforms to the legal system that need to happen to prevent those situations from happening. It's obviously not a very easy thing to assist a specific case, and this is very long-term change. But the entire world is created in such a way so as to not provide what is necessary for persons with disabilities to enjoy their rights. And when they come into contact with the justice system, it's almost always the most painful experiences. And these principles, I think, can be very useful for advocacy to change legal systems and legal processes to try and make it much more possible in the future to be able to litigate on these issues.
Yes, thank you. I'm going to say a few closing words. I think that the question to which we've arrived at the end regarding Article 19 and the right to living independently in the community is a quite representative one for understanding the complexity sometimes of the rights issues at hand, and how, at least in Sweden, and I'm sure in many other countries too, that the legal frameworks are not very good at actually fitting the rights and the litigation or possible litigation to have the rights materialized in the internal procedural frameworks. It's just not how the rights have been managed in the national context. So I think this is where we wanted to end up with this webinar, to find that there are remedies, there are possibilities across the globe, but it's not always the case that you have all of them in one country. So you don't necessarily have the opportunity to easily litigate on the rights just by referring to them. You would have to find other more detailed avenues. And I think coming back to the systemic change also regarding remedies is a really important one. Not forgetting legal aid so that you can actually access those remedies We've heard stories also about the urgency of the matter in personal's testimonies. So I think we have a lot of work to do, and I would be happy to keep collaborating on this international area too, regarding remedies and access to justice. And with that, I think we should close this webinar and continue this discussion elsewhere. So thank you very much, everybody, for attending. Thank you, Julia, for captioning.
Thank you very much, Ola.
Thank you.
Good performance.